Iconic, The Economy of Certainty, An Introduction to the Typology of Islamic Legal Theory by Aron Zysow, Harvard University, Cambridge, Massachusetts, 1984. The Abstract. Abstract. The great dividing line in Islamic legal history is between those legal systems that require certainty in every detail of the law and those that will admit probability. The latter were historically dominant and include the leading legal schools that have survived to our own day. Zahirism, also pronounced as Zahirism, and, for much of its history, Twelver Shi'ism are examples of the former. The well-known dispute as to the legitimacy of juridical analogy is only one feature of this fundamental epistemological division, since probability can enter the law in the process of authenticating prophetic traditions and in the interpretation of the revealed texts, as well as through analogy, qiyas. The function of consensus in Islamic legal theory is to reintroduce some measure of certainty into the law by identifying one of the competing probable solutions as correct. Consequently, consensus has only a reduced role, if any, in those systems that reject probability. Another more radical means of regaining certainty was the doctrine that regarded the legal reasoning of all qualified jurists on matters of probability as infallible. The development of the legal theory of systems of both types, Zahirism no less than Hanafism, was to a large extent shaped by theology, in the first instance and most significantly by Mu'tazilism, and consequently by Ash'arism and Maturidism. End of abstract. Table of contents. List of abbreviations. Page 1, Introduction. Chapter 1, The Authentication of Prophetic Traditions. 1. The Concurrent Tradition. The conditions of concurrency. The classification of concurrent knowledge. 2. The mashhur, the well-known tradition. 3. The unit tradition. That means the ahad, the unit tradition. 1. The unit tradition in Hanafism. 2. The unit tradition in Zahirism and Hanbalism. 4. Discontinuity. The mursal tradition. Inner discontinuity. Summary. Chapter 2. Interpretation. 1. The nature of Islamic hermeneutics. 2. The hermeneutical apparatus. 3. The linguistic postulates. 4. The imperative. The deontological value of the imperative. The performance of the commanded act. Chapter 2. Interpretation continued. 5. The general and special terms. Introduction, theological background, specialization of the general term, hermeneutical procedure. 6. Zahiri hermeneutics. 7. The argumentum a fortiori. 8. The argumentum a contrario. Summary. Chapter 3. Consensus. 1. Introduction. 2. The basis of the doctrine of consensus. 3. The operation of consensus. 4. Tacit consensus. 5. The consensus of the majority. 6. Inqirad al-asr. 7. Consensus after disagreement. 8. Zahirism and the support of consensus. 9. Conclusion. Summary. Chapter 4. Analogy. 1. Introduction. 2. The foundations of analogy. Arguments for analogy, anti-analogism, the explicit cause. 3. The non-causal analogy. 4. The epistemology of the cause. Appropriateness, effectiveness, formal methods. 5. The ontology of the cause. 6. Al-masalih al-mursala. 7. Istihsan. Please refer to the Shatibi series for these terms. Al-masalih al-mursala means public interest. Istihsan means that which is judged to be good amongst several probable judgments. 8. Specialization of the cause. Summary. Chapter 5. Ijtihad, which is legal reasoning, or expending effort in legal reasoning. 1. Ijtihad and probability. 2. Infallibilism. 3. Consequences of infallibilism. Summary. Epilogue. 1. The supposed Zahirism of Ibn Tumat and Ibn Arabi. 2. 12 Shi'ism. 3. Conclusion. Bibliography. List of abbreviations. Stay tuned for the introduction and many more parts.